Hey, I want to talk a little bit about civil law, in particular for college students. Now, I said civil law. Why civil? Well, keep in mind there's two major types of law in the United States. Criminal, in which case you can go to jail, or civil, in which case you can lose money. Two very different court systems. Today we're talking about civil. Now, where would you be heard if you're going to court on a civil issue? Remember, just money's involved in this case. Well, you're either going to a state court or a federal court. If you're going to a federal court, the first court you'll be heard in is called the district court. If you want to appeal from there, well, of course, you go to the appeals court. And there's even a chance if you appeal from there that the Supreme Court of the United States will grant you a writ of certiorari or grant you cert, which means you can be heard in the United States Supreme Court. That's on the federal side. On the state side, well, the very lowest of the low courts is the inferior trial courts. This is simple things like traffic court. You don't need an attorney, the fines are small, you're in and out quickly. However, if you're on a civil issue, you're probably going to be in the trial court level on the state side. Trial, then appeals, then the state Supreme Court. So very similar court structures. Now, whether you go to state or federal depends on several things. The first thing that I want to talk about, though, before we go there, is simply that for any court, state or federal, to hear your case, they have to have two things in place. Number one, they have to have subject matter jurisdiction, which simply means that they have to normally hear the type of case that you wish to bring. If it's property, the court needs to usually hear property cases. Let's take a specialty court, though, like a tax court or perhaps a patent court for United States patents. You couldn't bring an automobile accident suit in a tax court or a patent court. Those are specialty courts. They won't hear it. So, number one, the court has to have subject matter jurisdiction, have to hear that kind of case on a regular basis for obvious reasons. Secondly, they have to have jurisdiction over the parties. Let's say that you and another person are involved in some kind of altercation. Well, if you are both residents of the same state, you're going to go to trial in that state. Just because you might hear that some great cash awards are being given in some particular state doesn't mean you can travel across the country and file suit in that state, because they don't have jurisdiction over you and the other person. You don't live in that state. You don't transact business in that state. You have no minimal contacts with that state. Therefore, you cannot bring suit in that state. Let's talk about how this happens. Civil dispute resolution. So, there's a civil issue that you want to have resolved. The first step is the pleadings. You need to let the court know what you're pleading. In other words, what do you seek a remedy for? After the pleadings have been written, there's going to be a complaint and a summons. In other words, the court has to let the defendant know what the complaint is and whether they're summoned to be at court at a certain time or simply respond in writing by a certain time. Now is probably a good time to mention the difference between plaintiff and defendant. Plaintiff is similar to the word complaint. The plaintiff is the one with the complaint. They're the person or the business that or the state that starts this whole act in motion. The defendant, of course, if we're talking about criminal, is innocent until proven guilty. The defendant simply has to defend against the accusations of the plaintiff. Now, if you do get a summons, a lot of times it'll come by certified mail. Make sure that you receive your certified mail, open it, and go to court. If you do not go to court and the other side shows up, the court will issue a default judgment against you. You will lose automatically. So a summons is a serious thing. Make sure you treat it as such. There's some pretrial procedure. You may say that makes some sense, but the trial is the big thing, right? No, actually, the trial is the last resort. Nobody really wants to go to trial. It's expensive. It's long. So what we have is judgment on the pleadings, discovery, a pretrial conference, and perhaps summary judgment. In other words, these steps are made so that the parties will come to a mutual agreement before the trial even starts, either amongst themselves or due to a ruling by the judge. If no agreement can be reached, we go into trial. First, we have jury selection. If it's a minor case, you may not be asked any questions at all if you're a potential juror. If it's a major case, you may be asked a series of questions. This is known as voir dire. What that simply means is that both the plaintiff's attorney and the defendant's attorneys want to ask you questions before they place you on the jury. This is to find out whether you will be fair and unbiased. In other words, do you present a level playing field that you can adequately relax and take in the facts and decide for yourself? Rather than, let's say, a potential juror who just finished reading the newspaper, a story about your client, and has decided that he or she is already guilty. You certainly don't want that person as a jury person. After jury selection, there's the conduct of the trial. After the trial is over, the judge will issue jury instructions. Why does a judge issue jury instructions? Well, you see, in a court in the United States, there's a judge and a jury. Why are there two separate things? Why does the judge do it all? Well, in the cases that we're talking about here, when there is a jury present, the jury decides the facts. Did that witness tell the truth? Do I believe that car was red or was it yellow? What are the facts of the case? That's the jury's decision. The judge, as you can imagine, has to decide the law. The judge is an attorney, or at least was an attorney and now is a judge. And the judge makes legal decisions to make sure that the law is applied directly. So the judge can't let the jury simply go off to deliberate without giving them some instructions as to what the law is and to exactly what they should be deliberating upon. So after the trial, the jury instructions, the jury deliberates, the jury comes back with the verdict. Now, if this were criminal, it would be, as you've probably seen on TV, guilty or not guilty. However, we're in civil. We're talking only about money. So the verdict is going to be liable or not liable. They owe money or they don't owe money. As simple as that. Now, where is it easier to get what you want? In the civil court system or the criminal court system? Well, I'll tell you, in criminal, it's very hard to get a conviction because the standard of proof, if the state wants to send someone to jail, they must prove their guilt on the criminal side beyond a reasonable doubt. If there is one reasonable doubt, that person goes free. After all, they're innocent until proven guilty. Sometimes you'll see on the news where a person is set free on the criminal charge, but then they're dragged into civil court and they have to pay as if they were found guilty, even though they weren't. The reason is it's not guilt or innocence, it's liable or not liable. And the standard of proof is much easier. It's the preponderance of the evidence. In other words, is it more than likely this person did what the plaintiff is saying? If so, they win what they're asking for, or at least some similar amount. After the verdict comes in, the attorneys are free to make motions based on the verdict. Set aside the verdict, overturn the verdict, appeals. There's a number of motions that are made after the verdict, depending on whether or not you want to move forward or you're satisfied with the verdict. There's also enforcement. Enforcement simply means you've won a cash award. Hopefully the person will pay and the matter is quickly ended. If not, however, you can use the court clerk and the sheriff to obtain some property, not all, to be sold to satisfy the verdict that you've won. That's called enforcement. Now, there's quite a few steps just leading to trial. Trial in itself is a long, lengthy process. Because people don't want to go to the cost, expense, and time, there's a large and growing field called ADR, Alternative Dispute Resolution. What this is a quicker, cheaper, perhaps easier and less stressful way to solve disputes. rather than going into this long river called the court system. The first form of ADR, alternative dispute resolution, and the most important is arbitration. And I say it's the most important because arbitration is binding. Arbitration is binding. That means you must abide or do what the arbitrator says. Now, let's say that you sign a lease for an apartment during your college years. Chances are that contract or lease has a clause that says if a dispute arises, this will be decided by an arbitrator. Well, remember that an arbitrator is to be neutral. In other words, the apartment owner has to agree on the arbitrator and you have to agree on the arbitrator. The reason is they need to be neutral to render a fair decision. If the apartment complex says, I would like to use Mr. Jones as the arbitrator, how is that with you? Make sure you call Mr. Jones and say, are you familiar with my apartment complex? How much business do you do with them? And if Mr. Jones says, well, all my business comes from that apartment complex, I would suggest you find a different arbitrator because their bills are being paid by that apartment complex and they're probably not going to be that neutral. After arbitration, there's conciliation and mediation. Conciliation, that's when one person travels back and forth between the two parties, relaying information, oftentimes in subtler, smoother, softer ways than the angry parties may have first said. You can see where a tactful politician can help parties reach a decision quicker that way. However, there's also mediation. Mediation is different from conciliation in that the mediator is free to propose their own independent third-party solutions. They can listen to one party, listen to the other party, and then present their own proposed solution to the problem. There's even something called med-arb, when there's a mediator, works between the two parties, proposes, and if the proposals are shot down, then the mediator switches to arbitration mode, and then there are no longer any options. Whatever decision is rendered is binding because we've gone into arbitration from mediation. There's also a mini-trial. Mini-trial is typically between two corporations. There's typically lawyers involved. However, it's the managers from each of the two corporations after this small mini-trial who negotiate and work out some kind of a compromise without the expense and time of going to trial. It's called a mini-trial. I hope this helps, and good luck in your studies.